right, Zoomers, give me a thumbs up or some kind of emoji if you can hear me.
I can hear you.
Is she saying, are they saying something?
If you're saying something, I can't hear you.
It's Sherry. I can hear. Can you hear me now?
Sherry's saying
Should
something.
be. Should be speaking.
And so is the
TV.
one, that's another chat now. Okay, all
Oh,
right, thanks, Sherry. It says it's using my microphone. Okay, I can't hear you guys, so if you have something, just throw it in the chat. All right. Okay, so one of the things that I'm going to talk about, a couple of things we're going to talk about today. I'm going to turn my video on just so you can see me for right now. So I'm going to go over kind of a summary of all of the changes that went into effect on July 1 this year. And then through our series will remain the same with forms. So first Wednesday of the month is listing forms. Second Wednesday is buyer forms, which is what we're going to be focusing on today. Third Wednesday is offer to purchase, and fourth Wednesday is miscellaneous. So we will stay with that theme. I'm just going to, for the next couple of weeks, I'm just going to give you an overview of all of the changes that happened with forms. And then each of those weeks, we'll dig into those specific changes. So offer to purchase, big change on there as far as due diligence and when it's due. The buyer has one banking day to deliver due diligence money now. They moved the home warranty from page 9 to page 2, where everything, all other concessions and everything else is there either between page 1 and page 2, meaning any seller concessions, your closing date, all of your information that's right there. So they moved home warranty up there for it to make sense. Instead of, oh, I'm on page 9 now. Oh yeah, and then it's like, oh man, I forgot that we agreed to do that home warranty and we're sitting at the closing table and guess who gets to pay for the home warranty? The agent. Yes. Another major change is just information on the offer to purchase on FinCEN reporting now. Now that is a new thing.
Oh, good question. Do they give rationale for why they make changes? Like you said, they went to the money, the first one you said about being 1 day now.
Yes.
Is
not always.
Oh.
They don't no, they don't always say,
Okay.
well, this was our thinking on this. And yeah, so no, not always. I think the reason behind it was that if something goes under contract on a Friday, and the buyer can't get to the bank to get a certified check until Monday, then it's still they still have that time to be able to do that.
there was some misunderstanding. People thought that once you're under contract, if you didn't have it, the seller could just walk away. Not necessarily true. You can't hold an offer hostage, so
Yeah.
you're not receiving due diligence money.
New construction addendum, some pretty major revisions there. Mostly, when do I use it and kind of what are the guidelines for when I use it. We'll talk about that when we do additional forms. A new form that they have is additional parcel exhibit. So on our on the listing, agreement, you know, that little box is there that says additional parcels for the attached. Hey, come on, come on.
Except to speak, it's Joe Don Baker.
Yes.
All security.
Additional parcel exhibit, okay, so on the listing agreement, and then it was also on the offer to purchase. But there was never really, there was a box that you could check, but then it was just like, well, how do I attach it? Because we can't draft documents. And, so now there's a form for that. Yes. Minor changes on additional provisions addendum, just some cleaning it up. A new form, a judicial sale addendum. So this would be if there is, if it's a court ordered sale, you would use the judicial sale addendum just because it protects the buyer should the court not approve or the bid gets upset. And it just kind of explains the process a little bit.
That's not foreclosure, that's court.
Court order, yes,
Tax.
yes,
Yeah. okay.
yes. So it would either be,
Could be a divorce.
it could be a divorce, yes. And so so it could be foreclosure or it could be partition sale.
But anywhere that the judicial system needs to make, or is a part of that decision making,
Correct. Yes,
which we don't run into a whole lot.
not a ton, no, but you know. Agreement to amend, just minor changes on there. Now you can add or remove both sellers and buyers. Biggest thing there. Major revisions in the offer to purchase and contract vacant land in congruency with the offer to purchase changes. Exclusive right to sell. We're gonna have some fun conversations around that. There are new marketing options for the seller to select. We'll cover those when we cover listings. Also change in compensation, the language of compensation on the listing agreement. No longer is Form 220 a required document in your listing paperwork. In fact, the seller does not do a Form 220 at all.
They will sign it when there's an offer.
Yes.
Yeah, as long as it's accepted.
Yes,
Does the buyer's agent send the
yes,
220?
and we're actually gonna talk about that today, yeah, in a little more detail. I'm just kind of going over
Gotcha.
the changes right now. Vacant land disclosure statement redrafted. So people didn't like the format. So they changed it to what they consider a better format. Exclusive buyer agency, we're going to talk about those changes here. Non-exclusive buyer agency, same thing, same changes on the buyer agency. Form 220, big change. We're going to talk about it on here. Professional services disclosure was redrafted. Personally, I like the old one better with the boxes. Because now they just have lines and I'm not there yet. No, I'm not there yet. No. Now they're just lines, and you know how whenever you put something in, it's like, oh, is it on this line or is it on this line? So I personally am not a big fan of it, but they did not ask my opinion on that. Yeah, so I mean that's the major changes that happened in our forms. Well, Tammy, you're here twice.
I did because I was gonna check the chat and see if it's something that what you're going through now, but only half from when I logged on, so I don't know what the chat is. There's may not be question.
Oh, okay.
See, I just can't get enough of.
I know. Wow.
I wonder if they commented when we were trying to hear them.
It might have
They
been
were, they were,
Oh,
his time to hear us.
one new, but that one new one is. I can hear it. That's from last time. I'm not. Okay, so now we're gonna dig into to the exclusive buyer agency agreement. Thank you, Mike. So this is a marked up version just to let you know, to give you a visual of what actually changed. So let me make it bigger. My little plus thing. Oh, here it is. All right, that looks a little better. Yes, is that a little better? Okay, so I know you hear me say this every single time. There's a reason I say it every single time, because after the 66th time that I say it, then you'll remember it. Or something like that. I'm not real sure. But anyway, so this agreement is between, so we put the buyer's name, we put the buyer's proper name, their legal name, not a nickname, not a pseudo name. So if I am representing Jim Wooten, I'm going to put James Wooten on my buyer agency agreement because that is his legal name. I have a new one. I've always picked on you, Jim, and you
That's
too.
okay. Would you put, whatever name that they would want on the deed? Or,
No, because the deed can be different.
because I'm James Holtby, but, so you just
Yes.
proper first name and last
Correct,
name. And that's it.
correct. Yes, yeah. So another example is Bud Hersey. Bud is not Bud's first name. It is not even anywhere in his name. So it's just a nickname. We want to make sure that we are using proper names. This may also be a trust. So a trust can buy something. An LLC could be an entity. And then firm is Keller Williams Central. Of course, if you are incorporated and you have your an additional license firm, then you would put both. So for example, here I would put Ward Real Estate Group at Keller Williams Central. So I'm disclosing both names. You can see in yellow the things that that have changed. Some of it's just verbiage and wording. They changed buyer has or has not signed a buyer agency agreement or other document to make it very clear that it is a buyer agency agreement, because could they have signed a showing agreement? Yes, they could have signed a showing agreement. Showing agreement is not an agency agreement. Showing agreement is just, I'm going to take you across the threshold. No obligation. There's no obligation on either party. It's just a one-time look. Term of the agreement. Again, some of these, there's no changes, but I'm going to go through them just like if you had to ask me a question of how to fill it out. So term of the agreement has to be a reasonable definitive date, and it cannot auto renew. So has to be a date, has to be reasonable. So we're not going to say 10 years. I don't know about you, but I am not working with a buyer for 10 years. So, it could just be,
Fine, okay.
well, yes, but no, it would have to be, yeah. But it could be, good point, Mike, because it could be a year if they're looking for a unique piece of property or land or something to that effect. So again, reasonable amount of time cannot be TBD.
Your house is driving miles.
Fee for services. So they added new construction on here. So typically, in most cases, we are going to check the second box, a fee of 3% of the property's gross sales price. So what they added was a fee of blank percent for new construction property based on the purchase price of the vacant land and the final cost of the completed dwelling. So that would be under a new construction property, because they made it very clear that it's not just the land, it's the land plus the build on there as well. Also a bonus. Can now disclose a bonus. A flat fee, if it's a flat fee, other specific amount. This is the place that we are encouraging you to add the $150 transaction fee. So you would simply you would check box number 2, a fee of 3% of the property's gross sales price. And then you would also check the last box, other specific amount, $150 Keller Williams transaction fee. Just so the buyer understands that this is not you, the agent, charging the transaction fee. It's the firm charging the transaction fee. And we want you to pass that on to your client.
Question.
Mm-hmm.
About the one right above it.
Yeah.
The new one.
Transaction fee.
New construction.
Oh, no, I'm sorry. The one about the bonus.
Yeah.
Is that when like, a builder is offering an extra bonus? You
Yeah.
put that right?
Yes,
Okay.
yeah, absolutely.
Everybody wants to get some vacant land and do a new house and whatnot. What if you start out with just, they're looking at regular residential things, flat fee 3%, and then they change courses and go, actually, we want to do new construction and land? Do you have to redo this agreement to have that box checked, or?
Yes, so you would modify what your compensation would be. And Carla, what form do we use to modify a agency agreement? 710.
7.
But yes, you're on it, you're on it.
Perfect.
Yes,
Okay.
yes. So you would use 710 to change what the compensation is. There's actually a box on there that you check that indicates what the compensation has changed.
So Karen, I've got someone that's gonna be coming into town in the next couple of weeks that they're gonna be looking at both
Mm-hmm,
new and existing.
mm-hmm.
Can I do 3 and 1 and 2.5 or 3 and 3? Check both boxes? How would, or do you have to have one or the other?
Yeah, I mean, you can check more than one.
Okay,
Yes.
because we all know typically new construction, they don't pay, some of them are now.
Right.
But most of them aren't paying just the 2.5 is what, they pay.
Right.
So,
Yes. Yeah.
Okay,
Yes. I think we're safe to go with 3. Just know that we can always modify it. But if you go with 3, because then if they end up buying vacant land and, they're paying 5, then you use Form 710 to unit 5.
either way,
Yes.
okay.
Yeah. All right. So here's another change under B. So seller, as you see that, or listing firm has been crossed out. Seller assistance. Buyer may seek compensation from the seller. Again, no more compensation coming from the listing firm, to pay some or all of the fee due in this agreement. However, buyer understands that a seller has no duty to pay the firm's fee. We'll dig into it a little more when we get to Form 220. Protection period. So again, this is if the buyer enters into a contract within X number of days. This could be 30, 60, 90, 120. Just remember that if they sign a agency agreement with another agent, that protection period goes away. All right, now we're going to get
And it's
into,
the standard people use for the protection. Is it 90 days? So,
it's not really a standard, but I mean, you know, again,
cause if they go into agreement with somebody else, it doesn't matter.
right, right.
I
Yeah.
typically do a 45 or 60 day.
Yeah,
That's what I
yeah,
normally
yeah.
do.
And if your agency agreement expired with this buyer and they haven't bought anything, you probably want to get rid of them anyway.
Depending on how long this agreement was for, that's true.
Yes, yes. Okay, dual agency. Yay, my favorite thing. Everybody clearly understands dual agency, right?
Yes, ma'am.
Wah, 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 wah. Okay, so on authorizations, we do not check all of these. That is not a correct answer. There are different situations where different boxes or lines are initialed off. There is never a situation when all of them have initials filled into them, because that creates something that it can't exist. Yes. So in most cases, when we are doing a buyer agency agreement, we are going to educate and ask the buyer to allow the firm to act as a dual agent involved in the transaction. So this one right here. Firm may act as a dual agent in a transaction involving the buyer. So what that means when you're explaining it to your buyer, what that means is that by you authorizing my firm to act as a dual agent, we will be allowed to look at other Keller Williams listings. So somebody else in my office may have a property listed that you're interested in seeing. In order for us to look at that property, you must authorize the firm to act as a dual agent. Okay, so then I'm going to go to my next conversation. So, but please understand, Mr. and Mrs. Buyer, that I will always represent you exclusively. So would you please initial right here where it says buyer does not authorize the same agent to represent both buyer and seller in dual agency, and directs the firm to practice designated dual agency. So what this means, Mr. and Mrs. Buyer, is that, again, my fiduciary responsibility is to you at all times. So if Carla in my office has a property listed and we go and look at it and you love it, Carla has a exclusive, a designated agency agreement with her seller. So she is only going to represent the interests of her seller. I'm only going to represent your interest. Carla and I are not going to collaborate on any confidential information that you share with me, nor will she share any confidential information that her seller has shared, with the exception of material facts. Does that sound good? Yes. All right, let's do it. So, you may have a case where the buyer does authorize the same agent to represent both buyer and seller in dual agency. There are some agents in our office that do practice same agent, dual agency. If you are a provisional broker, don't even think about it because it's not, you can't do it. And those of you that aren't provisional brokers, I would strongly caution you. And let's maybe have a conversation about the situation before we go into that same agent, dual agency. It's one of the biggest complaints with the real estate commission because even though you may have been as unbiased as possible, there's always going to be somebody that gets their feelings hurt and thinks, well, you didn't represent me as well as you represented the other party. So gets a little hairy. The second line, I begged them
They still pick.
to take it out. They kept it in there. But I do not know a situation where you would sign this. I mean, perhaps there are, and I guess I always make it, it's all about Keller Williams Central, right? But I guess that there are some firms out there that do not practice designated dual agency. Our firm does. So line 2 is kind of redundant because it says the exact same thing that lines 3 say, but then line 3 goes into the designated dual agency piece of it. So summarize. Initial here and initial here. Only one in each section.
Karen, would it be safe to say that you guys would prefer, rather than dual agency, represent the seller and the buyer be unrepresented? Because I've done that.
Yes, yeah,
That's what-
absolutely. I'm a huge proponent for sub-agent of the seller. Yes, yes. If it's an unrepresented buyer versus doing dual agency. There are some situations and circumstances where, it would be okay. Particularly if it's like, maybe a family member or the neighbor is buying it and, in some instance like that. But in most cases, if it's two people that you don't know, you know the seller now at least. But if this is not a buyer that you've been working with, then I would stay away. Yeah, sub-agent of the seller. Okay, other thing that they added on here is just the FinCEN disclosure. So this is the Financial Crimes Enforcement Network. With the Department of Treasury, it investigates and prosecutes financial crimes, collects and analyzes transaction data for this purpose, among others. FinCEN's residential real estate rule requires certain professionals involved in residential real estate closings, including closing attorneys, to submit reports to FinCEN regarding certain transfers to legal entities or trusts. The rule aims to increase transparency and combat money laundering and terrorism financing. However, and this is just saying, it may increase your closing costs. We have nothing to do with this. This is handled by the closing attorney. Pretty much all we're doing is saying if it's cash and it's going into one of an entity or a trust, then the closing attorney is going to have to file and report certain information and documentation to the Financial Crimes Enforcement Network with the Department of Treasury. Okay, on our signatures, please, I'm asking nicely, type in the buyer's name here. Because sometimes, on Lone Wolf or whatever e-signature platform you use, a squiggly doesn't say to me, is it really that person? So if you could at least just put the buyer's name in there, because believe it or not, I have had things, everybody makes mistakes, but I get a fire agency agreement that has a different name than the working with real estate agent. So, again, if the buyer is an entity, so LLC, corporation, trust, then you would put the name of the entity or trust, and then by who's signing it, who's authorized to sign for it, their name and title, and then they sign their human name. Not, and I don't know, I don't have enough experience with Lone Wolf yet to know, but with DocuSign, you used to have to trick DocuSign. Because it would put the, would autofill, and so it would want to sign as Ward Real Estate Group. Whereas it needs to be Karen Ward. A human always has to sign on behalf of an entity. Firm name, Keller Williams Central, license number C21388. If you didn't already know it, has to be signed by you, the agent, and include your license number as well, and the additional information. So if you are, I gave you the example of Ward Real Estate Group at Keller Williams Central. So when it says firm license number, I'm going to put C21388/C23495. Because that's my license number for Ward Real Estate Group. Any questions on the buyer agency agreement?
Not a question about that, it's a same question.
Mhm.
But when I looked my firm number up with the real estate commission, it was 23522. You know what that means?
She's showing us the big down there or something.
Yeah, she is.
Click on it. On the left, choose
That's it.
52.
That's it.
I just saw the number.
Yeah.
You know when you're trying to like write contracts and stuff, like.
Yeah.
And I just looked at it real quick and put that, and then when you said that, I'm like, wait, that's not the number. I need.
Yeah,
I
'cause
just want to make sure.
You're going to show as dual affiliated because you're the broker in charge at Hillsborough. That's the Hillsborough number. Any questions from our Zoomers? Zoom. Oh, I see the chat filling up. Hold on.
It's the phone. 336.
Are you manning this, Tammy?
Oh, yeah, but I just seen it in this.
You always have to.
Is she here? Or is she in the Hillsborough? Sherry?
Who's asking? Sherry. Well, everybody's address comes here. Yeah. And I don't know what the Hillsborough number is. Oh, thank you. Denise, I think maybe we figured that out for you. You can see my screen. I know when I first started talking, I didn't have it pulled up, but then I shared my screen, so has as we went through the form. All right. No other questions on this? I'm going to go a little bit backwards here. I wanted to make sure that we got that in. This is only going to take me a few minutes to go through this. This is the property showing agreement. So this is what I like to refer to as the speed dating agreement. We're going to decide if we want to continue our relationship. So this is, again, buyer, just like we talked about on the previous form, and firm, services provided. So this is where you could either put a very specific address, if you're on AOD, or you get a lead and they say, I want to go see this property. And we talk about agency with them and they're like, I haven't been pre-qualified. I just want to go look at the house. Yeah, one of those where it's like, all right, I'll give you one, but that's it. So that's where you would use this, this showing agreement. Could be a specific address. It could be if, like, Mike's got a client coming in town, if he just did a property showing agreement with them and not a buyer agency agreement with them, then he would put Alamance and surrounding counties, because there may be multiple properties that they are looking at. Firm may require the buyer to sign another agency agreement if buyer wants firm's assistance with the offer. If the buyer does make an offer with the firm's assistance, firm expects to be paid 3%. Other showing or agency agreements buyer has or has not entered into. If they have, they agree to provide us with the agent's contact information so that we can confirm that we have the ability to provide the services to the buyer. Term of agreement, same, must be a definitive time and reasonable, and it does not auto renew. This is going to be a much shorter time frame than your buyer agency time frame is going to be. Like, this may be 48 hours. It might be, you know, a weekend from, you know, Friday to Monday. This is going to be a short term because we're not just going to show and show and show without the buyer signing an agreement with us. Because there is no compensation tied to this form. Fee, if you charge a fee, then put that amount in there. Or if you don't charge a fee, check the box that says no fee is owed by the buyer under the agreement. Dual agency, firm may or may not act as a dual agent. Again, if it's a Keller Williams listing, then the buyer must authorize the firm to practice dual agency. Same as we just talked about. Any questions on this one?
That's something we should have.
Are those old or they're old?
Oh, yeah.
Yeah. All right. Working with real estate agents. This is our very first form, even though I'm talking about it thirdly. Working with real estate agents, disclosure for buyers. So when we are explaining agency, as I kind of role played and explained how we would present it to our buyer at a buyer consultation, our firm provides buyer agency relationship. We also practice dual agency. Again, this is the firm. And then we also practice designated dual agency. So you would want to check the top 3 boxes. Make sure that you include your agent license number and firm number. Now, Gabe, I'm going to go to you here for on this one. So you get that unrepresented buyer. You have a listing. Buyer says, I want to make an offer on this house. And you're like, well, do you want representation? You're entitled to have buyer. No, we bought 10 houses. We just want to make an offer. Here are the terms that we want to make. Okay. I need for you to sign this form. And that's when you're going to check the unrepresented buyer. And that's the only document that you need from an agency standpoint, because you're not representing them, would be from a compliance standpoint.
And this past week's NC Realtor brief, the legal brief that they sent out was regarding an agent showing their own listing to an unrepresented buyer, and that it went into a lot of detail about how that should be handled.
Yes. And an agent showing their own listing to to an unrepresented buyer does not require a showing agreement, and it does not require a buyer agency agreement.
Just this.
Just this, yes.
And does this always have to be signed? Like, it would be out of order if you signed a buyer or a showing,
No, you can do a showing.
and then
Showing and WWRA are gonna go at the same time.
you never want to wait for this.
That's correct.
Always
Yeah.
upfront.
For substantial contact, yeah. So when you show up at the property with that, property showing agreement for them to sign before, on the hood of your car, before you walk into the door, they're gonna sign the WWRA as well. All right. Form 220 used to be called, oh, thank you, yes. Used to be called cooperation compensation. It's still Form 220, but the name is now buyer agent compensation addendum. So we're identifying the seller. We're identifying the buyer. We're identifying the property.
Don't lick your finger.
This addendum is attached to and made a part of the offer to purchase and contract between the seller and the buyer for the property. Compensation and affirmation by buyer. In addition to any other concessions, credits, or expenses seller has agreed to pay in the contract, if any, seller will pay at closing X amount of dollars or 3% of the purchase price towards the buyer's obligation to pay their real estate agent. Buyer affirms that the scope of their agency agreement includes the property and that the amount in this paragraph is not more than the amount buyer has agreed to pay their agent. Okay, so the amount that is in here is the same amount that you put on your buyer agency agreement. So when you said, buyer, you're gonna pay me 3%, 3% is the same amount. Because you can't say, all right, buyer, I'm only gonna put 2 for you, but we're gonna ask the seller 3. No, it matches what is on your buyer agency agreement, and the buyer is signing, saying, yes, this is what that is.
I mean, technically, the buyer agency agreement already says the same thing,
Yes,
that it should match. I mean, not that it should match, but that's what you're gonna see.
Yeah.
So why not?
yes, yes. So, interesting conversations around this. Number 2, and I think this is where it's very important that we spend some time on this form, explaining it both to our buyer, because it's now being presented by the buyer, not presented by the seller. It's being presented by the buyer, but that as a listing agent, we are also spending some time explaining this once we receive it with the offer to the seller as well. So buyer and seller both affirm that they have an independent contractual duty to pay their own agent, and that no agent can be a third-party beneficiary of this contract. Seller understands they have no duty to pay any buyer agent compensation unless agreed to herein. The amount, format, or rate of real estate compensation is not fixed by law and is fully negotiable.
So this is how we get to the 6%.
Nope, this is just your side as the buyer.
Cause it's saying buyer and seller both affirm they have a contractual duty to pay their own.
That is correct. So the listing agent has an agency agreement where the seller is agreeing to pay their listing agent.
Okay,
The buyer agent has an agreement that says the buyer is going to pay them. Now but now the buyer is asking, and with this form, the buyer is asking the seller to contribute to what the buyer owes their agent.
oh, okay, so the buyer is asking the seller to contribute to them, and they're also gonna pay their own agent.
That's correct.
Okay,
Yes.
okay.
Yes. Yes.
Does that
That's
happen?
the
a lot?
way that it was the old way, same but different,
Okay.
if that makes sense.
So do we still call the
I wouldn't.
listing agent and say,
No,
be sure?
no, because it's part of your offer now.
Okay.
So you're submitting an offer and, so the seller used to dictate, this is what I'm going to pay, or this is what I'm willing to pay. Now the buyer is asking the seller, this is what I agreed to pay my agent. What are you willing to help me out on paying this amount to my agent?
Last week, I would have been getting paid 2.5%. Talk to you, got an offer in this week, got it accepted, didn't even ask the question. Submitted it, 3%, they didn't bother, they just said.
Yeah.
If I would have asked, then I would have been above and beyond asking for 3%, because they
Right.
already told me.
Right.
Rather not ask.
Yeah, don't ask.
Yep.
Yeah, absolutely, because you're submitting it as part of your buyer's offer. Because technically,
We don't even sign this anymore.
that's right, that's what I'm saying. There's no agent signature
No.
on this anymore. This document is an agreement between the buyer and the seller as part of the offer to purchase and contract. So you're gonna wanna make sure that you attach this to under other addenda. I begged them to put a box. I don't know why they didn't put a box. Like specifically says, check the box and type in Form 220. I'm like, why couldn't you just create another checkbox? So, a little bit of a change for this, for those of you that, learned how to do it the old way, you have to unlearn it. Change your mindset. For those of you that are brand new, you didn't know any different, so this is just the way that it is. Any questions from my Zoomers on this?
Technically, I'm a Zoomer, but is this replacing 220?
This is 220.
This is the new.
This is, yeah, this is the totally revamped, revised, this is 220, yes.
And the
Yeah.
percentage of the purchase price, is that, and if I misheard something or missed this, is that hey, I'm asking for my full 3%, or is this like, hey, we need you to catch the other 0.5%?
No, we're asking for the full
Full
three.
thing, not making up for whatever my buyers are doing or something like
Right,
that.
yeah. So whatever your buyers are doing, your buyers want to ask the seller to do. So if your buyers, your buyer agency says 3, we're asking the seller
Got it.
to pay that 3%
Perfect.
on behalf of the buyers.
And obviously, if this is sent back to us, negotiated,
It's a counter
Counter
for the
offer.
offer.
then it's kind of the offer, and we can do that, but as long as it still adds up, what we'll compensate us add up to 3%. So in other words, if they came back and said, instead of 3, we'll pay you 2, then you gotta get that 1% from the
From
buyer,
the buyer.
or you have to change
Yes,
the buyer's.
yes.
And real quick, the third party part, like in case I get asked, I'm not sure I know. It's under negotiation.
No agent can be a third-party beneficiary of this contract. Okay, so what, they can't get paid outside closing is basically what, no monies are outside of this agreement. So
Well, this is gonna show the credit from the seller to the buyer on the
buyer.
closing statement. And then the buyer's gonna show the buyer's fee in their column now, I would imagine.
yes, yes.
Well, what's the third party? So in other words, we can't give this money to anyone else. Is that?
So,
bottom line?
well, so basically what it's saying is that we can't be a third party to, any of the, so a listing agreement says this, buyer agency agreement says this. Neither one of those parties can pay us outside of that agreement.
What is a third party? Okay.
Well, we're a third party in the contract because we're not part of the contract.
Parties to the contract are the buyer and the seller.
Can be a third party. What doesn't that say? We can't get paid then? And that no agent can be the third party.
No, it's just that our fee is gonna be coming from the buyer.
Yeah, I'm just trying to understand what this, you know what I mean? In case
Yeah,
someone
we're
asks.
not getting paid on this. This is just saying that the seller is going to credit the buyer
Yeah,
for closing.
And then the
The
buyer
buyer
will
will
pay us.
pay you a commission.
But we're not a third party of this
Yes.
agreement, because the two parties, the buyer and the seller, are, the seller's funding, giving money, basically a
Credit.
concession.
Okay,
I mean, it
So
could
that's
be,
why we're not signing, that's why our name doesn't appear anywhere on
That's
that.
correct.
Is that a better way to clarify that? There's no third party, I'm not part of this, you guys are in agreement.
Yes,
This is.
buyer and seller are agreeing on how I'm going to get paid. We're talking about it from a buyer agent standpoint, how I'm going, you and the seller are agreeing on how I'm going to get paid at closing.
so going back to Gabe's, scenario of 2%. 2% is when you go from the seller to the buyer, and then the other 1% is gonna come from the buyer. All of it's gonna show that it's going to Keller Williams Central from the buyer.
And like maybe to help, maybe I think I have this right, a third party, like, example could be a roofing company that's getting paid for something like a credit and closing for work to be done. Would that be correct? That would be a third party, just to kind of different.
No, because it specifically states no agent.
Okay, okay.
Yes, yeah. So anything like that, those people, they still have to be paid on the settlement statement.
Mhm.
It either has to be paid outside of closing directly by whomever the party is that's responsible for paying it, or, in best cases that it shows on the settlement statement.
Karen, Denise asked, will the seller's agent have any information available prior to the offer to let us know what percentage they have agreed to?
So they will have their listing agreement that says, what the seller has agreed to pay. But again, it's negotiable. So we're gonna send in what we expect to get paid, which would be 3%. And then buyer and seller can negotiate it from there. So gone are the days where we are calling the listing agent or texting the listing agent or lassoing or carrier pigeon, trying to get in touch with them on what's your seller offering as compensation. Now it's proactive from the buyer. The buyer saying, this is what I agreed to pay my agent, and I'm asking you, Mr. and Mrs. Seller, to contribute to that, what I've agreed to pay my agent. I think it's gonna be a good thing. I think it's gonna put the, it's going to, the pendulum, I feel like, will swing back towards the full fee agent. Because it's not the agent arguing over anything. So emotions from,
Yeah.
Agent to agent or whatever are out of it. This is between the buyer and the seller.
So once you get your buyer, or you get you get your buyer to sign it, then who gives it to the seller?
It's presented with your offer.
Oh,
So it's an
okay.
addendum on, you have to mark it as an addendum, check the box and type in Form 220.
Okay,
Yes. And it's presented with the offer.
okay.
Yes.
I think it'll prevent buyers from coming in and really lowball offers too,
Sure.
potentially.
Yeah.
Because if they're going in asking for 3% and they're coming in $30,000 low, I mean, if I'm the listing agent, I'm probably gonna say, okay, seller, you probably are thinking this, but we're probably just gonna not pay this. We'll take the offer or whatever.
Yeah.
But we're not gonna do this.
Yes. But
Because
that's the other thing, is that the buyer now has to understand
Mhm.
that if the seller
Yeah.
doesn't pay that amount, that the buyer is still responsible for paying that amount. And there's a lot of ways, I hear all the time, well, my buyer can't afford it. My buyer can't afford to pay my compensation. Well, let me give you a little secret. Your buyer is paying your compensation. Whether it is directly to you or whether it is an inflated list price, purchase price that they're gonna pay to the seller. Ultimately, your buyer is still paying your compensation.
even if they negotiate out the price, in essence, the buyer's paying.
Yes, yes. So it's, again, it's a mindset shift of my buyer can't afford to pay my compensation. Well, your buyer can't afford to buy a house. I mean, it's, it's the way that it is. There's a lot of okay, number one, we're gonna ask the seller which is what we did before. Old forms said, we will try to get it from the seller first. However, understand, if the seller's not willing to pay, it's still the buyer's responsibility. So it's that shift in that conversation, particularly at your buyer agency, is that I charge 3%. My compensation is 3%. We're going to, and it says it in the buyer agency agreement, we're to seek that as a credit from the seller to cover my buyer your obligation, Mr. and Mrs. Buyer, to pay me that money. So, it's always been, well, the seller pays commission, the seller pays commission, the seller has never paid commission. And so we've got to shift that language to say, buyer, you hired me. And so it really, to me, it makes total sense now, right? Because the seller hires the listing agent. Hi, welcome. Oh, we got some Zoomers too. You can wave too. So the seller hires the listing agent. The seller and the listing firm have an agreement on what that compensation is going to be. Okay. The buyer has hired you and the firm. So you and the buyer decide what the buyer is going to pay you for your services. So it's, if you go to get your oil changed. I'm gonna give a crazy example here. You go to get your oil changed, you don't pay for yours and the person's behind you. I mean, unless you're doing a good deed. I typically do it in the Starbucks line, but if you wanted to do it in the oil change line, then that's an option too. So same thing. You're not paying, the person that is receiving the service is who's paying that person. To just kind of simplify.
So I did have one comment from when you said this last time in Hillsborough. They never have. I said, think about it, they have. Well, it's always showing on the closing statement that it's coming from the seller. I couldn't convince them otherwise, so I left it alone. Old school agent,
Yeah.
I know who I'm talking about.
Yeah. Sure, I did.
So just know that that may come up
Oh, yeah.
at some point from some of the veteran agents
Sure.
that don't
course.
quite understand the new concept.
All right, any questions? It's 2:02. Man, I nailed it. I used to be 7 minutes over and that was with the old forms and I even explained other changes. Any last questions before I, Zoom you Zoomers off?
Nope, Sherry just said thank you.
You're welcome, Sherry. Thanks for being here. Thank y'all for being here.
Aaron, are you guys, or did I miss, did you go through the listing presentation?
Uh,